professional expertise. This is just a couple of extracts from the Crown Office and Procurator Fiscal Service. It's a guideline and booklet information for bereaved families, and was written in 2007. There might be some amendments to that following the most recent review, but most of that will hold pretty good there. And here, as we say, the discretion to instruct a fatal accident inquiry, and if there's public interest, and that's really where your area would come under scrutiny, that if it was in the public interest for some clarification, some investigation as to what actually happened in those circumstances. The second one I'll come back to in a little bit more detail in a moment, but it is public interest, public concern, opening the issues up to the public. This is not an exercise in the apportionment of fault and blame. That would be the preserve of perhaps another court case, another investigation, but that is not the purpose of an FAI. And again, I just thought that'd be an interesting quote, the third one there. And here, the Crown Office is saying isolated incidents involving errors of judgment, for example, one-off medical errors, will not normally provide sufficient justification for discretionary FAIs. If, however, this inquiry is held, it is very stressful for all the professionals and the families who are involved with the patient prior to their death. It changes the relationship very often between the healthcare providers who have maybe had a very long, or indeed perhaps less long, but very intensive relationship with the patient who is in their care. They and the families have bonded in being able to discharge the best possible care for the individual, and they now find themselves in uncertain ground on what happens in the future. Inquiries can be held as often as a year after the death has actually occurred. Not only is that a massive weight that rests upon the professional and the next of kin, but it also plays tricks with one's mind. Something that was very, very clear at that particular moment and very visual and very vivid can sometimes be eroded with the passage of time. The fact that an inquiry is being held at all indicates a degree of concern on the part of the legal authorities about the circumstances of death. And the professional themselves face the prospect of their management being closely scrutinised in the public arena. As to the actual process, if one is asked to attend a fatal accident inquiry, I have a friend who's a psychiatrist, and he tends to teach his students and say, imagine you are a gladiator and you are going into the gladiator's ring to entertain the crowds. You don't know whether you're going to be facing lions, tigers, some other unknown animal, or indeed another gladiator. On that basis, you don't know what armoury to wear and what weapons to take with you. Imagine all of that, and you've got some idea of what it's like to be called as a witness at a fatal accident inquiry, because you have no idea of what you're going to be facing. Sometimes the line of questioning can be quite peaceable, quite gentle, and sometimes it can be a little more hostile, but you simply do not know until you get into the arena there. The organisation of these inquiries are also not such to promote any equanimity among the witnesses. You can end up being waiting to give your testimony for many hours. Sometimes you can sit there for days and not be called at all. The hearing, as I say, is formal, and by the time you have the numerous legal representations that tend to be involved, and I'll detail those in a moment or two, days and days and days can sometimes go by before you actually get your turn to give evidence there. The evidence is led by the various parties, and the witnesses can be cross-examined just as they would normally be in a court of law. Relatives of the deceased are entitled to question witnesses and can engage their own legal representation. The fiscal then finally re-examines the witnesses to clear up any uncertainties and ambiguities on behalf of the legal parties. Other parties can call additional witnesses, and the same process of examination, cross-examination and re-examination takes place. Professional and expert witnesses can therefore be in the stand for many, many hours at a time, and they can become very, very skilled in being able to put forward their case. I cannot emphasise enough the importance of the role of expert witnesses in medical litigation today. The nuances and the subtleties of medical technology mean that judges and laypersons, even such as myself, have no idea about medical technology and medical niceties. We rely totally on the expert evidence that is brought before us by those who would have a much better idea. And how it tends to work in the United Kingdom and many other common law jurisdictions is various expert witnesses will be brought forward, perhaps at least one for the prosecution and at least one for the defence, and usually very often more. And the way negligence works in Scotland is it isn't a matter of right and wrong as to how perhaps one treatment or procedure is carried out. As long as we have an expert witness that says, that was okay, I would have done that in the circumstances, I would have carried out that treatment in that way, even if you had others that said, I would not, it does not matter, because that person will be defended on that basis that there was an agreement, it would have been a reasonable treatment or procedure to go ahead with. Let me just give you a case, I told you we weren't going to escape with this, that just illustrates the nuances and the subtleties of expert witnesses. It's an English case, happened in 2003, a case of Blytho. And what happened here was a young boy, just a baby, a few months old, 6 months old, was taken in with respiratory problems. His mum took him in to the emergency unit and they kept an eye on him. And like all toddlers, 1 minute he was kind of running around and the next minute he was not, he was turning blue in respiratory difficulty. They kept the wee boy in and he went through this sort of up and down situation, and about 3 o'clock in the morning, as these things always tend to happen, he was beginning to get very distressed indeed. They paged the on-call registrar, who did not get the call because the batteries in her pager had gone flat. By the time somebody actually came to attend the wee boy, he had died. The question was not one of negligence per se, because the hospital admitted that they had been negligent in failing to provide somebody to attend. But the question was, had this individual registrar got the call and attended, would she have intubated this young child? There were two schools of thought on this. The first one was, yes, you would intubate in order to relieve the immediate difficulties and clear the respiratory tract. Apparently the other school of thought is that you would not tend to intubate a child of that age because the longer term damage on organs that were still developing would have been more detrimental to his health and well-being. And she was basically asked, had you attended, what would you have done at that time? And she said, I wouldn't have intubated. So in other words, even if she had attended, she would not have intubated and this wee boy might have died. And the expert witnesses, of course, then had to come in and decide whether this was an appropriate treatment in those circumstances. They spent 80 days deliberating this case as to whether or not it was appropriate treatment not to intubate. If they had managed to show that it was inappropriate treatment, which they did not manage to do at this time, then the hospital would have indeed not only been negligent, but the failure of this registrar to attend would have caused the young boy's death. They were unable to show that, but the court took the opportunity of saying, whilst they'd heard nigh on 80 days of expert witness at that time, they still had to apply legal principles. So it is a huge, huge and complex area for legal expertise trying to get clarification on medical nuances. The employing organisation, such as the NHS, trust or board, will usually have a solicitor or advocate in court to represent its interests. Care has usually been provided by a multidisciplinary team, and the patient will have been in contact with a number of professionals prior to their death. Each of these professionals will usually have legal representation. Again, the role of these lawyers is not to contribute to a consensus or to have a dispassionate search for truth. It is quite explicitly to protect the interests of their clients. Just a quick slide here. The importance of good record keeping. The main source of professional evidence is the patient's case notes. Notes that are comprehensive, accurate and legible is essential, is absolutely essential if clinicians are going to be able to defend their assessments and their actions at that time. An incomplete record can place the healthcare practitioner in a vulnerable position, and healthcare professionals should never forget the adage, if it ain't on the case note, it did not happen. At conclusion of the evidence, the fiscal will make a submission to the sheriff covering the circumstances of the death and the evidence that has been heard, and will invite the latter to make a determination. It will usually involve the following: where and when the death took place, the cause of death, reasonable precautions, and defects in the system of working that contributed to this death. I cannot emphasise enough that the sheriff has no power to find fault with individuals or apportion blame or guilt between persons whose acts or omissions may have contributed to this death. The sheriff can make recommendations as to how these deaths may be avoided in the future, but such recommendations to date are not legally binding. And sheriffs indeed normally make about recommendations in about 1/3 of any FAI. I was trying to find some case studies for you, and as I say, good news that I didn't actually maybe find one directly applicable to your life and times, but I thought this one illustrated the process and procedure quite well here. Here we have a 15-year-old girl, Lisa Norris, and it was really more the circumstances in her death which led to quite high-profile media interest and a discussion whether or not an FAI should take place. In July 2005, Lisa was then 15 and contacted NHS 24, and thereafter her GP, complaining of abdominal pain, vomiting and headaches. She was then looked after locally with her GP, was referred to Ayr Hospital and then transferred to the Southern General Hospital on the 18th of August. At that time, following a biopsy, she was diagnosed as having pineoblastoma, so she had cancer. Lisa's treatment for this cancer was a combination of chemotherapy and radiotherapy, and she received chemotherapy at the Sick Children's Hospital in York Hill and radiotherapy at the Beatson. It was established and recognised and admitted by all parties that she received an accidental overdose of radiotherapy treatment at the Beatson between 5th of January 2006 and the 31st of January. The error was discovered on the 31st of January, and investigation then took place. Lisa died on the 18th of October 2006 while this investigation was still taking place. During the investigation, there were differing medical views expressed by experts that continued throughout the initial inquiry. One expert thought there was a link between the accidental overdose and at least